Hello, this is attorney Jeremy Hogan, back with you again for another Legal Briefs Crypto Edition. If you are involved in the crypto or blockchain world in any way, stay with me because after the break today I'm going to share with you what the SEC is doing right here in the US of A. And it's not only about Ripple, it's about every crypto out there. You have to hear this because it's extremely terrifying. Now, I'm really only supposed to be doing one crypto vlog a week, but once I saw what I'm about to show you, I couldn't really unsee it. I needed to get it off my mind. Now, if you're young and impatient, what I'm going to tell you in the next 15 minutes or so is that I have found that the SEC has a long-term plan for regulating crypto in the US, and it's not good. It's actually pretty scary. And no matter what crypto you own, you are not safe. Okay, kids, that's the summary. Go back to playing Halo now. Now, for the older and wiser in the crowd, stay tuned because I'm going to show you exactly why you should be scared, how the SEC is weaving its web, why Ripple being first might be a good thing, and maybe at the end, which cryptos will gain an unfair advantage based on what the SEC is doing, so you can begin to think about your portfolios in terms of regulatory danger. It's very interesting and also very scary. But first, I have to do the disclaimer. Do not take anything I say as legal or definitely not financial advice. I don't know anything about you, and I just do these vlogs for fun. If you need a legal opinion, call this guy. Who can tell me the name of the movie in the comments? Anyone? Also, as a plea for help, I am not active on other social media or Twitter. I just don't really have the time for it. So please share this or link to it if you can. I feel like there should be some kind of SOS out to the crypto community out there. But in any case, let's get going. Now, this vlog is a little more difficult than most for what I do, so I'm going to share my outline with you as I go through it so you can follow along a little bit easier. So now we're at Roman numeral 2, history of SEC enforcement. Now, in order to truly understand what the SEC is doing, you have to understand briefly the regulatory framework the SEC operates in. As you may know, the SEC enforces the 1933 Securities Act and at the same time propagates its own rules, which provide its interpretations of certain areas of securities law. I think of the SEC kind of like a criminal prosecutor who has discretion in who gets arrested, but also issues opinions letting people know who are likely to get arrested based upon the laws that are being applied. Now, as you know, the SEC regulates sales of securities ostensibly to protect buyers, and what is legally a security is guided by the courts and the factors in the Howey case, which basically says that a sale of an asset is a sale of a security if the purchaser is relying on the skill and effort of the seller to increase the value of the asset. Now, that's the nutshell version. So let's take a look at Roman numeral 3 now. This is the years 2010 to 2016. In addressing initial coin offerings in the crypto world, the coin offerings had started back in 2012, 2013. During this period, the SEC was very quiet, especially during these first 5 years. There were no enforcement actions, and if there were any discussions about crypto and what to do about it, it was all behind the scenes. Now, why that was, I'm not certain. But the crypto world was so new then, I think the SEC might not have been sure how to address it. Now, moving down to Roman numeral 4, we see the first wave of enforcements began in the 2017 period with the Dow case. Everything changed for some reason in 2017 when the SEC became more active in crypto regulation. You might say that it was dragged into the fray because the Dow organization got involved in a scandal which kind of screamed for some kind of regulatory involvement when about $50 million of the Dow token was diverted into an attacker's account. You might also realize that this coincided with the reign of Clayton at the SEC, and that might have been something that had to do with it. No one really knows, but this was really the first action involving a crypto world. Because the Dow had taken great cares to build a decentralized network and organized similar to a partnership, the case was not a slam dunk. And the SEC let it go when it found that the founders of Ethereum basically decided to repay the victims of the theft, which, by the way, led to the Ethereum and Ethereum Classic breakoff. But recognize because it was not a slam dunk case, the SEC never filed litigation against it, but just kind of let it go at the end of the day. All right, the next case to look at is the Munchie case, which I love the name of. The next major enforcement action in the first wave here was against the Munchie app. The Munchie company had made an app where people could write reviews of particular dishes at restaurants and get tokens in return. Now, the problem was at the time of the ICO, there was not even an app in existence for the Munchie app. So the Munchie company, it was small, it didn't have a lot of money, it was in a weak position. And as soon as it knew that the SEC was pursuing enforcement against it, it basically gave up and entered into a consent settlement. And the SEC used that weakness to get a ruling that expanded the definition of a security. This is extremely important because this case found that the token was a security because the offerers promoted the profit potential of the token, even though the token was technically not a security. Let me repeat that. If the seller of the token even suggested that you can make money from buying the token, that is a security, no matter whether it really is or not, according to the SEC. And that's what we got from the Munchie case. Okay, now moving down to Roman numeral 5, the second wave of enforcement, which is 2018-2019. In 2018, we have the second wave from the SEC, and the SEC focused on the Paragon and Air Fox coins. And now we see the SEC actually filing lawsuits and making an argument in court. Now, the Paragon case in particular was important because Paragon had some money to fight with. They had raised, I think, over $100 million in their ICO. But the facts of the case were weak for Paragon, and it did eventually settle the lawsuit. Now, looking at the facts in the settlement judgments for Paragon and Air Force, what is clear is that the SEC emphasizes two legal points. One, that the proceeds of the sale were used to build the service, and also that it was marketed as such. So again, an emphasis on marketing, the SEC expanding the definition of what a security is and using weaker players in the crypto world to get there. Now, early 2019 saw the SEC take a stab at some small exchanges in the Token Lot LLC litigation. Token Lot rolled over fairly quickly. Notice that the SEC was not taking on the big exchanges like Coinbase or Binance, but much smaller, weaker companies, and the enforcement actions led to successful judgments against these smaller exchanges. But the really big action in the second wave was the lawsuit against Kick Interactive, which we have discussed on this channel in some detail, I think twice previously. This was a big lawsuit for the SEC. Kick had a little money to lawyer up, and indeed it did put up a fight all the way through summary judgment where it lost, completely lost. Here the SEC put a new spin on its argument by saying that Kick did have a decentralized platform for the token, but the platform was not very functional, so in effect it didn't really matter. Now, this judgment highlighted that the SEC can argue the weaknesses in the decentralized platform and added to the SEC's quiver of arguments. Again, you see the SEC stretching the definition of what a security is, and here we can say that, oh, well, there was a decentralized platform, but it wasn't very functional and therefore it doesn't count. Okay, moving down to Roman numeral 6, the third wave. At this point, I think you might be seeing what the SEC had been doing for the last 2 or 3 years from 2017 to 2019. Remember, the American legal system is built on precedent. If the precedent is from a same level or lower level court, it's persuasive, meaning the judge should give it some weight. If it's from a higher court, the judge must follow it. It's what the SEC was doing from 2017 to 19. It was building case precedent and expanding its reach on all the prongs of the Howey test. And it was doing this by preying on the weak, the weaker companies, the weaker legal positions, and using them to get the case precedent and stretch the boundaries of what is considered a security. Now, I used to work for a very large insurance company, and I have seen this tactic used many times in litigation. For example, when an insurance company wants to defend a certain position, it has legal team meetings, everyone is brought in, and we're all looking at where the weak cases are, who the weak opponents are, and the goal is to pursue those cases first before going after the strongest enemies, because you want to have good case authority on your side when you eventually do end up in front of a judge and you are taking on a stronger opponent. We would always want at least 3 to 4 cases where we had won previously and we had written judgments, so that when we went in front of the judge, we could throw those cases in with our initial briefs. It's always a good thing to be able to tell the judge, Your Honor, Judge Smith and Judge Cruz, who you work with and sometimes go to lunch with, have both ruled in our favor before, and here's their opinions, and here's why they ruled that way. So think of the SEC in 2017-19 like a young lion. Does he attack the largest bull? No. He goes for the young and weak at first. And then when he gets bigger and stronger and more confident, he goes for the bigger bulls. That is exactly what the SEC was doing. It was preying on the weak. And now that it's been eating for 3 years, it was ready for the bull, which takes us up to December 2020 and the lawsuit against Ripple, which is the beginning, just the beginning of the third wave. The lawsuit against Ripple is a full-grown lion attacking a full-grown bull, if I could stay with that analogy. Ripple is a rich company that can afford to spend millions of dollars defending this lawsuit, which is why it's hired 21 lawyers to defend it. Ripple didn't have an ICO last year. It issues its tokens more than 5 years ago, and it has numerous decentralized platforms in place. So the case is not a slam dunk case that the SEC has focused on the last couple of years. This is a much more difficult fight, but this is the fight that the SEC has been preparing for. But what is more concerning than this lawsuit is the anti-crypto position that the SEC is taking and its organization in pursuing its litigation efforts. And when an insurance company pursues a litigation strategy like this, its goal is to kill whoever or whatever is going after. I've seen it happen, and make no mistake, the history to me makes it clear that the SEC is not the friend of the crypto economy. When you take a look at how the SEC has expanded its definition of a security over the last 3 to 4 years and how it's bided its time before the Ripple lawsuit, this is a regulatory agency that wants control and dominion over the crypto blockchain world and believes it should, because it believes that everything is a security. And the SEC might not be alone. Take a look at the article where Congress extended the SEC statute of limitations for 10 years. Now, I don't think that the SEC might be all alone in this. When I first read the SEC v. Ripple lawsuit, I thought that many of the things referenced in the lawsuit took place 7, 8 years ago. I looked up the statute of limitations. It was 5 years, and I thought, that could be an issue for the SEC. Well, literally the next week, I was researching that issue again when I found out, lo and behold, Congress had snuck into the Defense Authorization Act an extension of the statute of limitations to 10 years, which takes us back to the beginning of the crypto world. Now, this law change was passed literally 2 weeks after the SEC versus Ripple lawsuit. Coincidence? I'm not going to go down that road much further. Okay, let's take a look at Roman numeral 7, conclusions and takeaways. Now, when I took a close look at how the SEC had been approaching enforcement actions from 2017 up to the Ripple lawsuit, I knew right away what was going on. It hit me right in the forehead. I'd seen it many times. This is a very common litigation strategy. The SEC was taking its time, expanding its case law quiver at the expense of smaller and weaker companies, and I've seen this done 100 times in many different contexts. But I was surprised because this strategy is usually meant to destroy someone or something, not work with them for further clarity, like I've been hearing in the crypto community that they need further clarity. And the SEC has been very successful up to this point. It's been textbook so far on this. And now they have the case authority positioned so that it doesn't even necessarily matter if a coin offering is a security or not, as long as the company suggests or markets it as a security. Now that's crazy to me. I mean, the SEC is locked in 3 out of 4 prongs of the test so that it can make a strong argument that every ICO is the sale of a security. And really, out of all the cases the SEC has looked at, I can find only one case where the SEC has determined on its own that a sale was not a security, and that was the turnkey jet token. It was a smaller token that allowed purchasers to use an already existing air charter service. But everything else is a security according to the SEC. Everything. All right, Roman numeral 8. What can we take away from this, and what does it mean for your portfolio? The main takeaway from our analysis of the SEC's actions is that it's not stopping at the Ripple lawsuit. In the SEC's eyes, every crypto out there, with the exception of maybe mined, decentralized, and immediately utilitarian tokens with a completely built-out application system, are subject to its regulations, and even then, I'm not sure. So the SEC believes that 99% of cryptocurrencies are subject to its regulations and oversight. Now, the SEC historically brings about 2 to 3 ICO-type lawsuits every year, and it showed us with the Ripple lawsuit that now it's not scared to take on big players. So if you own anything maybe other than Bitcoin, I would be nervous. Actually, I am very nervous myself. Even though someone said a couple of years ago that Ethereum is not a security, and that statement came from the SEC, that doesn't lock them in on whether they can pursue Ethereum or not. So take a look at your own portfolio. Do you own any coins where there was an ICO in the last 1 to 3 years? Do you own any coins where the sellers marketed the idea that the value, the coin would go up in value? Do you own coins where the ledger is not completely decentralized, or where the use cases for the token are not completed yet? The SEC could be going after your holdings next. So as an investor, what does this mean? Well, for holders of XRP, they've actually seen what happens when you get sued by the SEC. First off, there's an immediate loss in value, there's fear, and there's uncertainty. But there might be a silver lining for XRP because being dragged into the tunnel first, it will also emerge first. The SEC only has one shot at these lawsuits. So if Ripple can make it out of the tunnel on the other side, then it's in the clear. Once SEC's lawsuit with Ripple is done, it's over and they can't bring it again. So in analyzing the dangers to my crypto holdings or your crypto holdings, I would be concerned about, first and foremost, my smaller coin companies. A smaller coin, even if it can and should win a lawsuit, might not be able to afford millions of dollars to fight it. And also, you have to understand it's extremely distracting for a small company to be involved in dangerous and protracted litigation. It really gets their eye off the ball, so it's not good for them either. Now, so watch out for the smaller and weaker companies. I would next be worried about coin offerings that happened more recently. My instinct is that the SEC is going to turn its focus to more recent offerings with the thought process that the newer companies should have known better. That's just an instinct, but they've taken some heat for how long they waited with the Ripple lawsuit, so that might be a new approach for them. And then, of course, I would look at whether the company had a fully decentralized, built-out platform before the coin offering. If not, the company is in danger. Now, there are too many coins out there for me to analyze any single one, but those are the three things I'd look for. My instinct is that Ripple is a big bite for the SEC, so it will turn its attention to smaller targets for the rest of the year before looking at another big one, but that's just a kind of educated guess. So in conclusion, it's obvious that the SEC's position is that almost all ICOs should be registered offerings of securities, and it is willing and getting more and more able to go after the crypto world. Take a look at what your money is in, because the biggest danger to your cryptocurrency, in my opinion, is the SEC. And if you think your favorite coin holding is safe because Ripple took the hit for you, I'm afraid that history shows you are sorely mistaken. And unless something changes at a higher administrative level, the SEC may very well be coming for your crypto next.